Hi, my name is Jonathan Culbertson, and I am the Senior Compliance Manager at InCheck, a background screening company. Welcome to the July 2024 edition of InCheck's Compliance Update Vlog. Now, the vlog briefly features some recent legal updates that affect background screening and the hiring process generally. And it is my intention to provide you with high-level summaries or alerts so that you can take that information back to your teams and legal counsel for further review. Let's get started with some recent legal updates that have recently become effective. Colorado's Job Application Fairness Act took effect on July 1, 2024. The act prohibits employers from requesting or requiring an individual to include their age, date of birth, or dates of attendance at or dates of graduation from an education institution on an initial employment application. So can't include it, can't request or require it on an initial employment application. Still, employers are permitted to request such information later in the hiring process, such as when conducting a pre-employment background check. Over to Maryland. Maryland's governor issued executive order that took effect on June 17th, 2024. Now, this executive order fully pardoned 175,000 cannabis-related convictions. Specifically, pardon convictions included those that met the following eligibility criteria. 1. Convictions for misdemeanor possession of cannabis or misdemeanor use or possession with intent to use drug paraphernalia. Convictions for misdemeanor use or possession with intent to use drug paraphernalia were in cases associated with misdemeanor cannabis possession and no other charges were incurred. Related disposition of guilty or probation before judgment, and charges occurring prior to January 1, 2023, when possession of personal use amount of cannabis was decriminalized. Now, please remember that a pardon is not an expungement, and it does not remove the criminal record from public records. Okay, now let's shift over to an amendment that was recently passed but has yet to take effect. Minnesota amended its Drug and Alcohol Testing in the Workplace Act to allow oral fluid testing procedures for drug, alcohol, and cannabis testing. Thus, employers will no longer be obligated to use the services of a testing laboratory as the initial testing method. Instead, employers may choose to request an employee or applicant to undergo oral fluid testing. In such cases, the employee must be informed of the test result at the time of the oral fluid test. Moreover, within 48 hours of an oral fluid test that indicates a positive test result or that is inconclusive or invalid, the employer or job applicant may request drug or alcohol testing or cannabis testing at no cost to the employee or job applicant using the services of a testing laboratory. In which case, all existing laboratory testing standards under the Act would apply. Now, that amendment takes effect on August 1, 2024. But please be sure to remember that Minnesota has a recreational marijuana law, which, among other things, generally prohibits employers from requesting or requiring a job applicant to undergo cannabis testing solely for the purposes of determining the presence or absence of cannabis as a condition of employment. And I please ask that you join me again next time for some more compliance updates. Thank you.